Before feedback, I want to mention this one more time. A female long-haired red dachshund has been lost in the Mud River Valley Proctor Mill Road area, wearing a rolled leather collar, answer to the name Pepper. And Pepper has puppies at home, and they need her back. If you see Pepper, please call 270-772-0389, 270-772-0389. Corey, I'm kind of concerned about Pepper's puppies. They need her to come home.
Oh, I agree. I love dogs, and I hate to hear that. I hope Pepper's found soon.
I do too. Well, Corey Morgan is here, attorney Corey Morgan. He answers your legal questions for free. Here's a wonderful opportunity to get questions answered, things that you've been wondering about. Call him up. He will answer them for you. And he probably has some things he particularly wants to on the top of his list to talk about today. Anyway, we'll get a break and come right back with attorney Corey Morgan right after these. Well, it's time for another Logan County Tobacco and Heritage Festival. And once again, the folks at Riley White are impressed and amazed by all the work that's done to make the festival a success each year. Countless hours and hours of planning go into the activities, and Riley White wants to express thanks and appreciation to all those hard workers. Your friends at Riley White hope you'll take advantage of the occasion to enjoy all the events that you can. Riley White wants to give the employees there the opportunity to enjoy the festival, so the store will be closed this Saturday, Parade Day. But Riley White certainly doesn't want to leave their customers in a bind. They suggest if you're going to need a prescription filled by this weekend, that you get your prescription in before Saturday. That way there's certainly no problem. You're getting it in plenty of time. However, if you have an emergency situation in which a prescription needs to be filled that day, call the emergency number 726-9318, and a pharmacist will be on duty to fill the prescription and discuss the best way to get it to you given the crowded square. And Riley White hopes you'll be able to enjoy lots of the events of the festival. Riley White on the square, downtown Russellville.
When you lose a loved one, a number of details must be worked out in a relatively short amount of time. The pressure of these decisions is only made worse by the grief the family is feeling. This is Wayne Reeves. Since 1959, our community has trusted Young Funeral Home to help them through this difficult time. As a family-owned funeral home, we understand the value of family and know that's how our friends and neighbors deserve to be treated. Young Funeral Home with chapels in Russellville and Auburn.
Attorney Corey Morgan here. Your calls are welcome now, 270-726-6100, or long distance, wherever you are, toll free, 1-888-610-WRUS. Corey, anything at the top of your mind this morning?
Well, I was going to talk about small claims some this morning, only because I've had several people over the last month have contacted me regarding small claims issues. Okay. So I kind of wanted to talk a little bit about that, and you just, if you will, just let me know whenever there's a caller,
calls, I'll wave or stand on my head or do something. Right.
Okay, that sounds good to me. Well, first of all, you know, small claims is a division of the district court. So here in Kentucky, you know, we've got a district court which has jurisdiction of, I believe it's $5,000. They moved it up to $5,000 not too long ago, and the small claims division is $2,500. So if somebody has wronged you, either they didn't pay you money or damaged property or whatever the issue may be, you can sue that person in small claims court for up to $2,500. Now, that is something that you would have to just go to the courthouse, and they'll give you the forms to do that. It has to be in the county where the defendant resides. Whoever you're suing has to be in that county. And you may think, well, the person owes me, you know, $3,500 or $4,000. I can't sue them in small claims court. Well, you can if you're okay with just going for the maximum of $2,500.
Okay, go for what you can.
Go for what you can, and you know, if you have to get an attorney probably eat up their other fees anyway.
Well, think about it. Now, in small claims court, you do not have to have an attorney. Is
correct.
That right? Or does anybody ever have attorneys in small claims court?
Sometimes they do. From time to time, I will help somebody in small claims. You know, they'll come to me and want me to represent them on small claims, but typically no. The reason why it's a separate division in small claims is it has no requirement for attorneys. Now, don't get me wrong. You do not have to have an attorney. outside of small claims, if you don't want to. If you want
treason, you don't have to have
No, you don't have to have one. You can represent yourself. But most people don't know. They don't know what the rules of civil procedure say, or the rules of evidence say, or the, if it's a family court matter, the rules of family court practice and procedure. They don't know what those say, so they have to get an attorney to actually get their claim to the court. Now, small claims is different. You file it, and you write down, they'll give you the form, you write down what happened and make sure you have the main facts in there. If it's somebody owes you money, you need to say how much the money is, when it was loaned, and things of that nature. If it's damaged, when the property was damaged, what the value of the property was, and things like that. And then once you file it with the court, the other person will be served, and they'll have a court date, and you go to court and argue the case before the judge.
So each individual normally will argue the case. He owes me this. Well, I don't owe him that because so-and-so. And do they each make their presentations before the judge?
Correct. They both make the presentations before the judge. The one who the burden of proof on is the plaintiff, the one who actually files the suit. The burden of proof is on them. It's called a preponderance of the evidence, which means more likely than not. So if, in fact, the plaintiff files, the plaintiff will go first in court and tell the judge his or her side of the story, and then the defendant, whoever is responding to it, can say his or her side as well, and the judge will listen to the facts and try to decide who, what the law, based on what the law is and what the facts are. Sometimes the judge has to kind of figure out it's a credibility issue, who's telling the truth and who's not being truthful. And it might not be that they're purposely lying. It may be just they misunderstand something, or they're not, they think something is that it's not. So the court will listen to that, and then the court will make a judgment. The judgment can be for up to $2,500. Now, say the plaintiff, and I had a situation like this that I talked to somebody recently, say the plaintiff sues the defendant for, I'm just going to throw some numbers out here, for $500, okay? And the defendant believes that the plaintiff owes him or her $5,000, okay? So the person who sued the defendant for $500, and the defendant believes that the plaintiff owes the defendant $5,000. In this particular situation, the defendant said, I'm not going to, I'll go to court on the $500, and later I will sue the person for the $5,000. And because it related to the same transaction, it was dealing with the sale of goods, because it's related to the same transaction, you have to hear everything at one time.
It's called put off the other.
Right, and so sometimes you may want to make a counterclaim. That's what it's called, a counterclaim against, defendant sue the plaintiff. You can do that. You can actually pull it out of small claims court if you want to, and have it, an attorney address it in district court. Because if it's, say, $5,000, the district court's got jurisdiction up to $5,000. You can pull it out of small claims and put it in district court if you needed to do that. Bottom line is, though, the defendant was thinking, well, I'm going to bring this later, but once that is heard, that defendant, because it's the same issues, that defendant cannot bring it up later. It's gone. So if the judge, ordered $500 to be paid by the defendant, that is the defendant's, because they didn't bring a counterclaim, it's gone. So, if there's anything that person owes you, you might want to go ahead and bring a counterclaim. And I spoke with a person, and the person told me, I was wanting to do it later, because it was more, and I might get a lawyer or whatever. Well, the problem, I said, you've got to get a lawyer now.
Yeah.
And unfortunately, the person came to me after there had already been a judgment for the other side, so then it's too late.
The whole thing is gone. It can't be brought up again.
Can't be brought up again. And so, it's even though it's a small claims and it's not typically a lot of money dealing with compared to other lawsuits, it still can be. That's enough money.
What about this a different issue? What at some other point this not connected with this particular instance, but another instance, could that be brought up again, or is that just knock the whole thing out forever?
The other instance, and that's a very good question. There are two types.
I'm not going to do this here, but in another case, he defrauded me out of so-and-so.
Right. Here's an example, and I saw this a few months ago. The plaintiff sues the defendant over a car, okay, and saying, the car that he got was defective, and it was sold knowing it was defective and all this. Now, the defendant said, well, the plaintiff owes me $2,000 from a loan I gave they were friends, or formerly friends, $2,000. And it was for a loan, a note. And the question is, well, if plaintiff sues defendant over the car and defendant doesn't bring up the note, is it okay for the defendant to sue on the note later? And the answer to that is yes.
Okay, so
because it's two separate things. There's something called a permissive counterclaim and some called what is that called? A permissive and a compulsory. Had to think about it for a second. Compulsory counterclaim. The compulsory counterclaim would be if it relates to the same transaction.
Okay.
But if permissive would be something that is separate. Now, the note, the defendant can either bring a counterclaim on the note at that time if they wanted to, or they could do it later. Now
suppose I get a judgment of $2,500 against somebody, or somebody gets a $2,500 judgment against me, but say that the person I get the judgment against does not pay it off. What is the recourse there? The judgment is for him to pay it, but if he just doesn't do it, what do you do then?
Well, a lot of people believe that, when they're filing suits, that the court is going to make somebody pay. They're going to use state resources to do that, and essentially that's not the case at all. A judgment sometimes is not worth the paper it's written on, and that's just to be very practical. Sometimes it's you can easily get the judgment paid. It depends on what it is. That's why a lot of attorneys, and I happen to be one of those attorneys, don't really particularly get involved in lawsuits unless there's an insurance company, because you're going to get paid. Otherwise, you might spend a whole bunch of time and money and effort, and then for not getting paid. Now, so the bottom line is you have to collect that judgment yourself.
And there's no debtor's prison. You can't
correct.
You can't have him put in prison until it's paid off.
That's correct. You have to use methods in which to do that, and those methods might be garnishment. You can garnish a check of somebody who's working. That's actually the easiest way. There's non-wage garnishment, where you can snatch somebody's bank account, whatever's in the bank account, which typically, when I do that, I'll usually do it like on a Friday, because you want to make sure, that if somebody's getting paid and the money's in there. If you do it on Monday morning, they probably spend it over the weekend. So, but that's another thing you can do. One thing that's interesting, and if any of you all who are considering a small claims, or you might be involved in a small claims one way or another, or you may have a judgment in small claims and you haven't been able to collect on that judgment. If you will Google, I'm a big fan of Google. You can get a lot of stuff from Google. Just Google Kentucky Small Claims Handbook, and there's like a little handbook that the state has put out that gives you some information on that. Another thing you can Google is Kentucky court forms, and that'll bring up electronic forms, and there's in there you can put, there's like a little menu on the right hand side where it's a drop down menu that drops down, and you can hit small claims. And when you do that, it just pulls up all the forms in Kentucky for small claims, and that's helpful if you're gonna file a lawsuit against someone. You can just type it up and then take it to the courthouse, and they'll notarize your signature, and then take it from there, and that way it's nice and clean, and you got time to think about it, exactly what it is.
Had they over the years occasionally changed the amount that qualifies for small claims as inflation, inflationary measure, and so on? That's
exactly right. I'm trying to think, was it 2012 maybe, or 13? I think it's 12. They changed it. It used to be $1,500, and Kentucky We're a very conservative state. That might be good, that might be bad. Some things is good, some things is bad. But with our exemptions what you're allowed to keep is very, very low compared to other states. Our small claims has historically been very, very low. I think we were the lowest in the nation at 1,500. So they moved it up to 2,500. We're still low comparatively speaking to a lot of states, but it does change from time to time, and that's a good question. Now, one other thing, when you go to the court forms, you'll see on there at the bottom, I believe it's listed is post-judgment interrogatories, or something of that nature, to where you can actually print out and serve to the other side after the judgment to try to find out, where they work, where they do banking, what assets they hold, etc. Another thing that's good to do is if you have a lawsuit, like a judgment against somebody, and you believe that person has real estate or may have real estate in the future, maybe they may inherit at some point, you can file a judgment lien in the real estate records, and it'll attach to any real estate that the debtor has. So if they're going to sell their house or anything, they got to pay you off first before the person can sell the house. Now, another thing I want to mention is a judgment is good in Kentucky for 15 years, and it can be renewed for an additional 15 years. All you have to do is try to collect on it, and it'll automatically renew for another 15 years.
If you haven't tried to collect, and it's apparently the court will think, well, you don't really don't care.
Correct, and they won't worry about it. They'll just let it.
If you're not worrying about it, we're not going to worry about it.
Exactly, and that's pretty much how the law is. The law operates that way. If you're going to sit on your rights and not exercise your rights, the court's not going to be concerned about it. They're like, well, he wasn't concerned about his rights, so we're not going to be concerned about him either. So that's typically how that is. Okay, we've got a call.
Good morning. This feedback. You're on the air with Attorney Corey Morgan.
Yes, sir. If someone owes you money and they have an agreement to pay you and they fail to pay you, what court do you have to go through to get a wage assessment?
Oh, okay. All right. I guess first of all, how much is the amount of money? Don't give me names or anything like that. We don't need any names, but
in one instance, it's $5,000.
$5,000. Okay. Is it? You said in one instance, so there are other instances as well?
Yes. There's additional debt loans.
Okay. In that circumstance, and they're not paying, you would need to go to the circuit court typically in the county where they reside. It could be the county where the transaction took place.
Okay.
But that's where it would need to be. And you would need to, you don't have to have an attorney, but it is advisable to get an attorney for that amount.
Now, if it is there a limit to what goes through that court? Like if it goes on up into $39,000 to $40,000, do you have to take it to a different court?
No, there is no limit in that court. The circuit court in Kentucky is a court of general jurisdiction, and it will, if you sued somebody for $10 million, it would be in that same court.
All right,
Anything above $5,000.
All right, thank you. Appreciate your help.
Thank you.
Thank you for calling. And Attorney Corey Morgan is here to answer your questions. Locally, 270-726-6100, or long distance, toll free, whithersoever thou mightest be, 1-888-610-WRUS. That's equivalent to 9787 WRUS. We'll take a break and be right back.
The prices are falling at your Russellville Piggly Wiggly. Stop in and rake up savings starting in the meat department. Family Pack Fresh ground beef is $1.99 a pound, and Family Pack Fresh assorted pork chops are $1.29 a pound. Pick up an 8-pound bag of jumbo russet potatoes for $2.99, or get a 3-pound bag of Michigan Jonathan apples for $1.99. Campbell's chicken noodle or tomato soups are 79 cents a can. Kellogg's assorted cereals are 2 for $7. Banquet meal varieties start as low as 88 cents. Plus, you can now save $8 instantly when you buy 8 participating Kraft food items in one transaction. Save big on Kraft Philadelphia cream cheese, just $1.49. Maxwell House ground wake-up roast coffee, $5.49 a can. Kraft mayo or Miracle Whip is $2.49 for the 30-ounce jar, and Kraft cheese singles, shreds, chunks, slices, cubes, crumbles, or cracker cuts are $1.99. It's savings galore all over the store at your friendly and convenient Piggly Wiggly in the Bethel Shopping Center, Russellville.
God looked down on his planned paradise and said, I need a caretaker. So God made a farmer.
Some folks are born to see the potential in a seed and share the land. RAM is proud to support the next generation of American farmers with the Next Crop Project. Saturday, October 17th from 10 till 2, Freeland Chrysler Dodge Jeep Ram will host another special Ram test drive event. They'll donate $20 to the Logan County FFA for the first 100 test drives. The Logan County FFA will be on hand in their cool vending trailer they bought with the proceeds of the last test drive event, and everyone who test drives a Ram truck during the event will receive a free ribeye sandwich meal. The National FFA is dedicated to helping future generations meet the challenge of feeding a growing nation, and Freeland Chrysler Dodge Jeep Ram is dedicated to helping the Logan County FFA. Do your part. Test drive a Ram truck during the Ram Next Crop event, Saturday, October 17th from 10 till 2 at Freeland Chrysler Dodge Jeep Ram, 1451 Bowling Green Road, Russellville.
I've often said air conditioning's my favorite modern invention, but to be perfectly honest, central heat doesn't fall far behind. It's amazing how much trouble it causes when a unit fails. But don't dare fret. Make one call to Knight Electric Heating and Cooling and they can do it all. They provide the entire WRUS listening area service on every make and model of HVAC system. Sometimes your unit will give warning signs when it's not operating correctly. That's why regular maintenance is important. Other times it just stops, and this is never on a perfectly temperate weekday. No, that unit's going to die in the middle of the coldest night or hottest day of the year. That's why Knight Electric Heating and Cooling offers 24/7 emergency service, too. Call 270-726-3818 and put the power of Knight Electric to work for you. Their trained technicians will quickly return you to a comfortable condition. That's Knight Electric Heating and Cooling, 270-726-3818. 270-726-3818. One call and they do it all. License number MO4318. And good morning, this is Feedback. You're on the air with attorney Corey Morgan. Hello, are you there? Ignore the TV because that runs later than us. Just listen on the phone.
Hello.
Okay? You're on the air with Corey. Don't pay attention to the TV because it runs a few seconds late. So you're on the air with Corey right now. Go ahead. Go right ahead. Just turn your TV down or ignore it. Right? It throws you off. Just go ahead. You're on the air with Corey. Can you hear me on the phone?
Hello.
Hello. Hey, turn your TV down because that's confusing you because it runs a few seconds late. So just totally ignore the TV and talk to us on the phone, okay? Are you there? I think we're having some...
I think so. She might not be able to hear on the phone or something.
Okay, can you not hear us on the phone? I think sometimes they want to listen to the TV and talk on the phone, and you can't... go ahead. Can you hear me now?
I can hear you.
Okay, just ignore the television because that runs late, and that throws everything off. Just ignore the TV and talk to us on the phone, okay?
Okay.
Go right ahead.
What I want to know is, what is the difference between a will and a trust?
Okay. That is a good question. A will is something where you're telling the court... I say the court because the will has to be probated, which means it has to be determined that it's an authentic will after somebody passes away. And the will tell the court what you want to do with your property after you pass away. And also it will deal with minor children as well. If you have minor children, you want a particular person to be named as a guardian. It also deals with that. A trust, on the other hand, is essentially a three-party type instrument. It is the person who sets up the trust is called the grantor. The person who runs the trust, meaning the person who oversees it and does what the trust instrument says, is called the trustee, and whoever has benefit from the trust is called the beneficiary of the trust. So you can set up a trust in a will, or you can set up a trust while you're alive. Maybe you want a trust to help a child, but that child might be a spendthrift or something like that, where you're concerned they're going to spend all the money, so you want to set it up in a trust and give them money here and there. You know, you can do that, or maybe it's a disabled child. Or maybe you don't want somebody to receive money until they're older, maybe 30 years old or something, because you're afraid they're going to do something with the money. That's what you do in a trust. But the will just tells who receives your property after you pass away and who oversees your estate.
Okay, thank you.
Thank you.
And thank you for calling. Somebody was trying to call a while ago and couldn't get through. If you call back right now, you're the one who was trying to call and you couldn't get through, call us right now. Locally, 270-726-6100, or long distance, toll-free 1-888-610, WRUS. Now, keep my eye on the phone here, and here it comes.
Okay.
Good morning. This is Feedback. You're on the air with attorney Corey Morgan.
Okay, Corey.
Yes.
Do you have to have a lawyer to fill out a will, or can you write your own?
You can write your own will. In Kentucky, we are one of the states, and I don't know how many states there are. I don't think there are very many that allow. I think it's called a holographic will. It's in your entire handwriting. If you write it out in your entire handwriting, and you sign it, that becomes your will. If you do that, you might want to make sure that there's a provision in there that deals with all the rest of my property. People kind of tend to leave that out. They may say, I want such and such to go to my, wife, but you at least need to put in there everything else goes to, such and such, or it needs to be all my property or something like that. And you always need to list who you want to be the executor, who you want to oversee the will, and
right.
That's yes. So the answer to that is yes. You do not have to have an attorney to do that. Attorney is always advisable. I would be neglectful if I did not say that, because sometimes people have things that that only an attorney can analyze. Right. Thoroughly to make sure it gets what you want. But small estate, it's not going to be as much of a big deal. But it does need to be fully executed in your handwriting and signed by you.
Right. Okay. Thank you.
Thank you.
And thank you for calling. Lines are open now. You can talk with attorney Corey Morgan, and it's difficult if you don't know what the size of your estate will be, and you want to distribute things in a I would say an equal matter, but in a percentage. You just come out and say, I leave to so-and-so 25%, or somebody else 25%.
Yes, that's best to do that, because you don't really know what you're going to own when you pass away. Hopefully, if I do a will, it's going to be a long time from now before I pass away, and I may have different cars, I have a different house. So it's good to be very, very general on that, unless there's some specific, like antique or something of that nature you want to give to somebody. We got a call?
Yeah, we do.
Okay.
Good morning. This is Feedback. You're on the air with Corey Morgan. Hello, are you there? Well, I haven't pushed the button. I guess if I pushed the button, it would help, wouldn't it? Good morning. You're on the air with Corey Morgan.
If you write your own will, do you have to have a witness?
You do not, if it's in your fully in your handwriting and signed by you. If it is not fully in your handwriting and signed by you, like for instance, part of it is typed, part or all of it is typed, then you have to have two witnesses. Two witnesses have to sign.
Okay, the caller dropped off. Okay, suppose somebody challenges and says, that's not his handwriting.
Then you get into
how do you do that, for goodness sakes?
Then you have to present people who are familiar with his handwriting, not for purposes of the litigation, but who just historically have known what the person's handwriting is, and then the court has to make a factual determination as to whether or not, in fact, that was the decedent's handwriting.
Well, somebody called and they bailed out again. Call us back. We'll put you right on. You mentioned something a while ago about, you mentioned insurance, and I'm thinking in trials in whatever court, and you're bringing an action against somebody, and you would like for the jury to know they have insurance, can cover the whole thing.
Correct.
And it won't hurt them. It only hurts this big old insurance company. Are you forbidden to bring up anything about insurance?
That's a very good question, and the answer is yes. You cannot bring up, in most instances, there's an exception nearly to every rule, but the general rule is you cannot bring up information to the jury that the person has insurance, because it is thought that the jurors will go ahead and find for the plaintiff, not caring what the facts are. They'll be like, oh, the insurance company's going to pay it anyway. when the plaintiff might otherwise lose if they thought the defendant was going to have to pay it. So that's why you can't bring up information about insurance. That's a particular rule of evidence. And we have rules of evidence in Kentucky. Every state does, and the federal government has their own rules of evidence. And in the rules of evidence, it says what can and cannot go before the court. Sometimes it's pretty black letter rule that you're like, hey, that's just straightforward. You cannot put it before the jury, and sometimes the judge has to weigh, whether or not the judge thinks it's more prejudicial to put it before the jury.
And I guess a very important decision in a criminal trial is whether this defendant's previous record is applicable to this, is relevant or not, and that's a big decision.
It is, and many times if a jury hears that someone has done something in the past, the jury will be like, well, he was
doing it again.
He was driving drunk in the past. He's probably driving drunk now. You're actually convicted on your past conviction, not on your present conduct, and that's one of the things that the courts frown upon. And I think generally, just think of it, the listening audience out there, just think of it, if you were charged with a crime, and would you want something brought up that happened years ago, and get convicted on that? Yeah, I wouldn't either. So that's why the court tries to do that. And that's what's so great about having the jury system. Is a jury system, you get people there who don't know you. The judge might know you, and if the judge doesn't know you, the judge might have heard about you. So the judge kind of, even if the judge is trying to be fair, trying to be neutral, it makes it more difficult for he or she to be that way. But the jury can just go basically on what the facts they hear in court and who they believe, and make a decision, not on your past history and that sort of thing. So yeah, the rules of evidence, they're vital to a fair trial for people, and sometimes even then it's difficult because the judge has to make certain decisions and balance certain interests between the parties.
And the lines are now open. You want to talk with Attorney Morgan, 270-726-6100 locally. In selection of a jury, a lot of times a case can be won or lost in the selection of the jury, can't it?
Oh, absolutely. I've heard attorneys say, particularly in seminars you go to, that a case is won or lost at voir dire. That's what's called. That's what jury selection is, voir dire, or in Kentucky, voir dire. It's something that you have to go through a process of asking questions to make sure the jurors understand that, first of all, what the procedures are, and to understand that the burden of proof is on the Commonwealth and things of that nature. But they also have to you have to make sure that person isn't predisposed to rule in a certain way. For instance, if I've got a case that's got a bunch of police officers, I don't want somebody who was formerly a police officer on the jury, because that person would be more likely to favor what the Commonwealth says. That's very important to make sure that the jury is as neutral as can be. Did we get a call?
Yeah.
Okay.
Good morning. There's feedback. You're on the air with Attorney Morgan.
Yes. If you have a revocable trust, can you still make out a will how you want your stuff to go?
Yes, and that's a very good question. And number one, if you have a trust, you still need a will, because most people still have items of property, even if a trust is being set up. And a lot of times people have something called a pour-over will. What a pour-over will does is it takes everything that's in your estate that you owned when you passed away and takes it and puts it all in a trust. So it's essential to have a will as part of an estate plan, just like a trust and everything else. So yes, ma'am. The answer is yes.
All right. Thanks for calling.
Thank you.
Talking a moment ago about a case now. Say you have a juror who is wants to get on, obviously prejudiced, keeps the information, nobody knows, and he gets on there, and obviously, or it turns out that he is favoring one side or the other. Probably one juror, that's the only thing he could do probably would be to get a hung jury in it if he's on there sabotaging the whole thing.
Correct. Yes. Sometimes you'll get a new trial whenever you have a juror who's deliberately withholding information.
Okay.
And if it's something that is innocently withheld, a lot of times it's treated differently. But if it's something deliberately withheld to sabotage the trial, that most certainly would get a new trial.
But now, if it's a criminal trial and this guy is in there deliberately to clear the defendant and is able to persuade the others, and through his prejudice gets the defendant found not guilty, that's it. I mean, regardless of how bad he was, that's
it.
But on the other hand, if he got a conviction through his chicanery, could be an attorney for the one who's convicted, you come back and say, this is wrong, we need a new trial? Or?
Correct, yes. That's where you get a new trial. You're not going to get it if the defendant is acquitted, you're not going to get a new trial. But if the defendant is convicted and you can show that there's some sort of problems, sometimes you can get a new trial.
I was noticing in Italy where this famous case where the girl from America supposedly killed another girl, and I've forgotten her name, but she was acquitted, and then in Italy they brought it back up again.
Right.
They probably do not have that.
They don't have the double jeopardy like we have over there. Yeah, they acquit the person, then bring it back, and then it really is. And I think that's one of the reasons why the founders put it in the Constitution is it really is a horrendously
how would you
horrible
ever know
process.
when you were ever through?
Right, you would feel like it was hanging over your head your entire life. We need, and I think that's one of the things they wanted to do is to have certainty. To have finality. It's done. You're done. Even O.J. Simpson, who's, a lot of people think is guilty of sin. He was acquitted. It's done. It's over.
I'll ask you something about O.J. in just a moment.
Okay.
Good morning. This feedback. You're on the air with Attorney Morgan.
Yes, if you make a will when your first wife is living and, of course, have left everything to her, after she dies, you remarry, and instead of making a new will, you just pencil in some things on that will that you would want done for the second wife. How does that work?
That's not effective. Penciling in, changing, you have to go through the entire process of having the witnesses and signing it in front of the witnesses, etc. Penciling in is no good. Neither is putting sticky notes underneath property items, like put a sticky note under a lamp saying who it goes to. That's no good either. It has to be through the formalities of a will, which it goes through, then it's signed and witnessed, and that's the only way that it is effective. Now, given the fact the person is now deceased, depending upon how the will's written, in all likelihood, it would not go to her estate. We'd have to see how the will's written and that sort of thing. But in answer to the question, yes, it does. Penciling in doesn't do any good at all.
But would that second wife automatically get everything, or would his children?
Both. Typically, a lot of it depends on how the will is written, but there is something called a spousal share in Kentucky, where a wife can take a share of the estate. And, regardless of how the will is, say husband has in his will, he leaves everything to the children, the wife can still take a share of that estate, even though it leaves everything to the children. So chances are both is probably the answer in your situation. Of course, I'd have to look at the document.
Yeah. Okay, thank you.
Thank you very much. Speaking of O.J. Simpson a moment ago, some people think that because there was such unhappiness about his acquittal the first trial, that this second situation, the jury may have been influenced. Okay, this armed robbery thing, he missed out the first time around. We're going to sock it to him now, and maybe some think the evidence maybe did not call for as serious a sentence as he got. So sometimes on down the road, karma or whatever.
It does. What comes around goes around. I'm one of those people. I believe that's why, O.J. Simpson got what he got, where somebody in a similarly situated would have been out of jail a long time ago, but that's just the way it is. People, sometimes even though there's no double jeopardy, sometimes you receive it anyway because if you do something, if he didn't do something stupid anyway, he wouldn't have to worry about it. But if you do something stupid in the future, your past is going to be looked at. That's just how it is, unfortunately.
Attorney Corey Morgan with us. You'd like to talk with him, have a question for him. You know how to do it. 270-726-6100 or long distance, toll free, 1-888-610 WRUS. We'll be right back. Well, it's time for another Logan County Tobacco and Heritage Festival. And once again, the folks at Riley White are impressed and amazed by all the work that's done to make the festival a success each year. Countless hours and hours of planning go into the activities, and Riley White wants to express thanks and appreciation to all those hard workers. Your friends at Riley White hope you'll take advantage of the occasion to enjoy all the events that you can. Riley White wants to give the employees there the opportunity to enjoy the festival, so the store will be closed this Saturday, Parade Day. But Riley White certainly doesn't want to leave their customers in a bind. They suggest if you're going to need a prescription filled by this weekend, that you get your prescription in before Saturday. That way there's certainly no problem. You're getting it in plenty of time. However, if you have an emergency situation in which a prescription needs to be filled that day, call the emergency number 726-9318, and a pharmacist will be on duty to fill the prescription and discuss the best way to get it to you given the crowded square. And Riley White hopes you'll be able to enjoy lots of the events of the festival. Riley White on the square, downtown Russellville.
Choosing a funeral home requires enormous trust. This is Joey Young. At Young Funeral Home, we've been earning the trust of Logan Countyans since 1959. Because we are a family-owned funeral home, we understand the importance of treating you like family. We invite you to call us at your time of need or come in and discuss the benefits of pre-planning a funeral with our staff. We create personalized services that honor your loved one. Young Funeral Home with chapels in Russellville and Auburn.
Somebody has emailed a couple of questions, and Chris, leave them on the screen, if you will, because I'll take this call, then we'll get into those. Good morning.
Okay, great.
Your feedback. You're on the air with Attorney Morgan.
Yes, I would like to speak to Attorney Morgan, please.
He can hear you, right?
Yeah, I can hear you. Yes, ma'am.
Okay. How would I go about finding out bills that I owe from way back?
The best way to do that is probably to go to the website www.annualcreditreport.com. That website is a free. You can get one free credit report per credit reporting agency per year. So, and that's not to say that everybody's going to be on there, but the lion's share of all your creditors will be on there, because because if they're older, at some point they're going to go to collection agencies. So, and any of my bankruptcy clients, I always require that they get those, because that's important to make sure that you know who the creditors are. But I would do that. Once again, that's annualcreditreport.com. It's free. It's set up by Congress.
Well, I don't know how to do www.com.
There is, do you have email?
No.
Okay. I tell you what, give my office a call, if you will. My number is 586, of course, 270 area code, 586-7777. That's 586-7777. I will send you a form in the mail that you fill out and mail in, and they will mail you back the reports within 14 days.
Okay.
Thank you.
Thank you for calling. Now, the email that Chris has referred to our screen here that someone just sent. A person died. There are 3 heirs, and one of them previously died. What happens to the deceased person's share? How does it have to be written so that it goes to the 2 remaining heirs?
Okay. The answer to the question is, if the decedent, the person who passed away, had a will, it goes by the terms of the will. If the terms of the will say if any of the beneficiaries pass away, that beneficiary's share goes to the other beneficiaries. If it says something similar to that type of language, then the other beneficiaries will receive that share. If it does not use that language and still has, each person's, like if you've got A, B, and C, and say C has passed away, A and B will receive their shares, and C's share will be received by C's children if C has any children, any surviving heirs. Okay. They will receive that. So.
Good morning. This feedback, you're on the air with Attorney Morgan.
Yes, I have a question.
Sure.
What is the length of time, like if you owe a hospital, you can go back on you?
You are cutting up just a little bit. The length of time if you owe a hospital bill,
yes,
that they can go back on you. Is that what we're saying?
Yes.
Okay.
Yes.
Typically, an oral contract in Kentucky is 5 years. A written contract is 15 years. So if you had something when you were going in, and you signed it, that would be a written contract. So it would be 15 years, typically.
Okay. I also got another question.
Sure.
Okay. I'm married, okay?
Mm-hmm.
And my husband left me like 3 years ago.
Okay.
How do I go about getting a non-contest divorce?
Okay. Do you know where your husband, of course no names or addresses or anything, but do you know where your husband is located?
He lives in Indiana.
Okay. Do you believe that he would sign documentation?
No.
Okay. The answer to that is whenever you have I'm assuming you've been in Kentucky for 180 days, correct?
Yeah.
Okay. And y'all have been separated clearly for more than the 60-day period by being 3 years. So you would be eligible to get a divorce at any time from the judge. What you would have to do is get an attorney. The attorney would file a petition, and the court would have to appoint someone called a warning order attorney. The warning order attorney is appointed to try to notify your husband. He or she may notify your husband or may not. Either way, you would be able to proceed forward and get your divorce. But they have to make a good faith attempt in trying to notify the other party.
And how long does that take?
That takes 50 days. From the time you file it to the time the warning order report comes in will be a 50-day period. Then you file a motion requesting a divorce decree, and you go to court. So, overall it may take, 2.5 months, 3 months, something like that from the time it's filed to actually get your final decree.
Okay, thank you.
You're welcome.
And thank you for calling. Still have time to take your call if you want to call. I was reading something about, I'm sure when you represent a defendant, you have some advice as to their appearance in court and
I do.
Courtroom etiquette and so on, right?
I do. Yeah, it is important to go to court looking like you would if you were going to an important meeting. Or if you go to church, wear the same attire that you would if you were going to go to church. And it really makes a much better impression. And I see people going to court dirty, wearing nasty T-shirts and stuff like that.
With obscene phrases.
Yeah, I've seen that too, with obscene phrases. And whenever you have something like that, it's not going to make a good impression on the court or on anybody. So try to do. You don't have to look like a lawyer or anything like that, but just try to wear something that will look nice. And because it really will help you a lot. In the long run, if you do that, particularly if it gets to where the court needs your testimony,
right.
or if you're at a jury trial. My goodness, at a jury trial, it can make or break a defendant as to how that defendant appears. If the defendant appears like a criminal, they're going to think you're a criminal and put you in jail. If you appear like a businessman and you're probably going to not receive the same treatment that you would otherwise. So. Anyway, do we have a call?
Yeah, we sure
okay.
do. Good morning. This is Feedback. You're on the air with Attorney Morgan.
Okay, I tuned in late. Where I began with you was on the small claims.
Okay.
I've got some questions, but I don't want to ask them over the phone.
That's
Do you
fine.
have an office in Russellville?
I don't. My office is in Franklin. And you're welcome to contact me by phone over there. It's 586-7777, or you can email me if and I'm not just saying it to you, but anybody out there just got a question by email. Please don't send me 3 paragraphs to read or anything. If you got a question that's important, because if it's 3 paragraphs, I need to have a meeting with you and we need to discuss it. But my email address is Corey Morgan Law, CoreyMorganLaw @iCloud.com. That's Corey Morgan Law at iCloud.com. You can send me an email and I'll answer it, or I may call you and talk to you about it, depending upon what it is. But I'd be happy to discuss that with you, ma'am.
Okay. All right. Thanks so much.
Thank you.
And thank you for calling. Still got time. Got a little over 5 minutes.
Okay.
Time for the call. Go ahead. Don't have it yet.
Okay. I was going to say, speaking of small claims, I did look up what I was talking about, the small claims forms.
Mm-hmm.
They have a small claims complaint, which starts the lawsuit, small claims summons, which summons the other party, a counterclaim, small claims counterclaim, motion for satisfaction of judgment. Whenever the judgment's satisfied, you need to file that to say, hey, we've received the money. Okay. Small claims post-judgment interrogatories, and small claims post-judgment motion and order requiring losing party to answer interrogatories. So if the person doesn't answer the interrogatories, you can ask the court to order them to. Go ahead.
Well, I thought we had a caller, but they bailed out. So I'm going to call right back. Well, here it comes.
Okay,
right now. Good morning, Miss Feedback. You're on the air with Attorney Morgan.
Mr. Morgan, have I heard you say before that you recommend that a married couple not have a joint will?
Correct. That is correct. A married couple does need separate. They do need separate wills. A joint will is really, it's not done very often anymore, and I think it's nearly malpractice for an attorney to do that anymore.
Well, why do you suggest that they not do that, not have a joint will?
Primarily due to the fact of the change in culture. Used to be people would get married and they would stay married forever. Now people get married, and a 5-year marriage is a long marriage. It really so if a husband and wife do that, it's a contract between the husband and wife, and say the husband passes away, the wife is stuck with that will, even if she remarries, which chances are high she will remarry. So joint will, I guess it would be okay for couples that are very old, that is unlikely to remarry, but joint wills typically are not good if one or the other party is going to remarry.
Okay, well, thank you very much.
You're welcome. Thank you.
Somebody else tried to call. We've got about 3.5 minutes. You want to call real fast? We can take it. What? Anything you want to talk about?
I did want to mention, when you go to court, small claims or otherwise, you have to prove your case. You can't go in there and say, "Oh, I've got that at home. Mm-hmm. I've got that document." I don't know how many times I've heard that, or so and so. Joe will tell you this. Well, Joe needs to be in court. When you go to court, you have to have everything there you're going to present, and whatever you don't have, you don't get to present. This will include things like photographs, audio, video, social media. You can present social media from the other side, any witnesses, any actual contracts or notes or any other agreements that you have, anything that you're trying to say that is important. You need to have that in there at that time. And remember, whenever you're going to file a suit against somebody, you can do some investigation before that suit is filed. First of all, you want to try to see if you can settle it. It's important to try to settle cases. Sometimes you may avoid litigation altogether if you just say, "Hey, look, I'm going to have to go to court."
Jesus even recommended that in the Bible. Settle your dispute before you go to court.
Absolutely. You want to try to settle it, and the person, if the person sees you're serious and going to take them to court, they may be able to work out something with you to where you can settle it. That's the first thing. Second thing is, if you believe the person's going to deny they had a contract with you or whatever, maybe it's an oral agreement, talk to them on the phone and record it. If you record it and they're admitting on the phone that the contract, you be very nice, say, "Hey, I just calling you, you haven't paid me. Why? We have this contract. and you owe me X number of dollars and you haven't paid me. Why haven't you? Can we work out something? And if they admit about all that, then that's something you can present in court as well. Then there's no question that there was an agreement. People get in court sometimes go, oh, I never agreed to that. I never got any money. It's important to investigate things as well before you go to court. Otherwise, it will come back to bite you.
And in Kentucky, only one party has to know that
correct.
That's being recorded.
Only one party has to know.
The guy you're talking to, if he doesn't know, that's all right.
Yeah, that's perfectly fine as long as you know that it's being recorded. Now, you can't record two other people talking. That's eavesdropping. Mm-hmm. One party to the conversation has to know it's being recorded.
Well, Attorney Corey Morgan, been a very informative show, and be looking for you next month, and maybe we can get to set up one of your law school classes.
That would be great.
Sometime in the interim. I'll be back with you. All right.
Thank you.
Thank you. Attorney Corey Morgan with us today. Want to mention again that a female long-haired red dachshund named Pepper has been lost in the Mud River Valley Proctor Mill Road area wearing a rolled leather collar. Now, Pepper has puppies at home, and she needs to be back there to take care of those puppies. They need her. If you see Pepper, please call this number, 270-772-0389. That is 270-772-0389. ABC News coming up here at the top of the hour on the 24-hour AM 610. WRUS, Russellville, Kentucky, ABC News, and then I believe